closed session meeting. Before we adjourn to closed session, the first order of business would be to ask if there are any speakers who wish to address the board on the matters on tonight's agenda. And just to be brief, tonight's agenda includes two items. Item B.1, public employment, public employee performance evaluation, title Superintendent, and B.2, conference with legal counsel, initiation of litigation pursuant to paragraph 4 of subdivision D, Government Code 54956.9, one case. And with that being said, I have 5 speaker cards, and in no uncertain order, well, no particular order, is the word. We have one speaker for B2 and several for B1. So the speaker for B2 is Mr. Benavides.
Good afternoon, board members. You know, many things. Oh, is this on?
Oh, no. I'm sorry. Put the switch on the top right there. Right.
Good afternoon, board members. You know, many many decades ago, our California elected officials passed the Brown Act. Its basic premise is that we, the people, have the right to know what our elected officials are doing. The mechanism for transparency in government is the requirement that you hold open meetings. Open meetings are favored over closed meetings. At an open meeting, it's a true sign of transparency in government. Over the course of many months, these boards have been deliberating important policy closed issues in closed sessions. And we, the people, have been deprived of our right to know what actions you have taken or hear you deliberate on those important issues. Transparency in government appears to be of little concern to the majority of this board. I have emailed each of you a letter where I have informed you that, in my opinion, to deliberate item B2 in closed session is a violation of the Brown Act. I have delineated my opinion, given the facts and circumstances that bring us to this point, and your determination to sue the County Board of Education. You can only hear B2 in closed session if you conclude that the Morgan Hill Unified School District will suffer a prejudice in its litigation if the matter is deliberated in closed session. That is not the case here, and my letter outlines why. You may think otherwise and disregard my opinion and proceed to deliberate item B2 in closed session. Today, some of you may get some satisfaction in exercising your power as our elected officials to make the initial determination to hear the matter in closed session. But be assured that the issue is not going to go away. For I, along with a large group of parents, are prepared to organize and fight to preserve our legal rights to have a transparent government. We will use every legal tool and procedures available to our citizens under the Brown Act to ensure that each of you is as concerned about our right to know as we are. I urge you to do the right thing and adopt the principles behind the Brown Act to ensure that we have a transparent government. I have the letter here that I'm going to hand out to each of you. Thank you, and I hope that you do the right thing.
Thank you, Mr. Benavides.
So we received this letter today. I saw it not even an hour ago. Knowing that there were some questions about the Brown Act, but before I ask our attorney who is here in the audience to address the question of the Brown Act, I just wanted to also go back to the questions that were raised by trustees in the past board meeting. The question raised by some trustees at the meeting on May 26, 2015, regarding the compliance with the Brown Act relative to the posting of the meeting agenda was what we had discussed at the beginning of the meeting. In a co-signed letter to me dated May 29, 2015, trustees Porgioli, Padillo, and Gerard again raised the Brown Act question and also expressed concern about how agenda items were identified before the board went into closed session. The requirements of the Brown Act are complex, and the district endeavors to comply fully with those open meeting laws at all times. When questions come up about our practices relative to the Brown Act, we promptly take those further steps that are needed to continue improving those practices. Because the agenda for the May 26th meeting was properly posted at various sites and was available online, our legal counsel concluded that the district was in technical compliance with the Brown Act. Even so, I acknowledge that the posting online appeared different from how it usually appears on our website, which we understand caused some confusion in the public. This was inadvertent. Moving forward, staff will take steps to ensure that the link to the agenda appears in a consistent fashion from meeting to meeting. We will also be reviewing our website to make sure that there are multiple ways in which the agenda can be accessed in the future. These safeguards will help avoid any future confusion and will make it as easy as possible for members of the public to locate the agenda. As to the closed session on May 26th, the agenda correctly stated that what would be considered in closed session. Additionally, no action was taken during that session. District legal counsel has confirmed that there is no further action that needs to be taken relative to the May 26th meeting. While there's no corrective action needed at this time, we will continue to review and improve our practices. If members of the board have concerns in the future regarding the posting of any agenda or any of the Brown Act issues, they are encouraged to call them to my attention as soon as possible and as soon as they are aware in advance of the public meetings. By working together as a governance team, we can help ensure that our practices continually are improving, and there is an opportunity to address any concerns prior to the meetings. This will help us make sure that we are keeping the public as fully informed as possible. So with that, I'd like Kanye to address the questions that came up with.
Before you go on, just comment that item that we just talked about is not on the agenda relative to letter that was sent to you.
This is in reference to the comment from the speaker in B2.
But you cited the letter from the trustees, and that's not on the agenda.
It's not on the
Before I talk about B2, I would note that the Brown Act does allow certain announcements to be made at the meeting. But I did want to address the board, Mr. Dennis, kind enough to share his letter. I've had a chance to look at it and look at the legal citations. I do want to assure the board that the Brown Act does allow the board to meet in closed session to discuss anticipated litigation, initiation of litigation under Government Code 549, subdivision 4. The board will be meeting in closed session to have discussions with its counsel regarding the potential for litigation. And since attorney-client privilege is confidential in the law, then that is allowable in closed session. I want to assure the board that the legal team has reviewed this section and believes that it is properly used in this instance for item B2.
Thank you, Mr. J. We have 4 additional speakers. These would be in reference to the second item, or in this case, be one public and one evaluation. The first card I have is Mr. Stephen Spencer.
Have the partner, got partner. So later on, I'll have this. Members of the board and staff, I would like to address the board on the superintendent's evaluation. I urge you to give him a favorable evaluation and offer him another contract. This school district hasn't had anyone in the superintendent's office has lived with Mr. Tano in quite some time. He can be reasoned with. He can have his mind change sometimes. But I urge you to offer him another contract and give him a favorable evaluation. Thank you.
Thank you, Mr. Spencer. The second card I have is Kathy Sullivan.
So the first thing I'm here is to just say thank you for the really good work that you've done this year and the past few years. I really like the direction that the district is going. I look at that as a leadership issue because Steve Tano, as your superintendent and the board, is making great things happen in this district, and I'm very excited about that. And I've taken the time to tell some of the schools that have recently won awards that how excited I am about it, but I wanted to come here tonight and thank you as well. But I did have some concerns because I know you are evaluating the superintendent, and I know that there was some concerns about the Brown Act violation. So I wanted to say that reading about what had happened at the last Morgan Hill School Board meeting, where 3 of the trustees accused the district of Brown Act violation for not properly agendizing the meeting caused me great concern. I would ask if the 3 trustees felt that the district staff had overlooked an issue as important as agendizing this meeting, why they didn't immediately check the staff to see if that was indeed the case or how they could best remedy it. Instead, someone chose to publicize the problem by contacting the newspaper about the concern. I was able to read about this issue online before the meeting took place. There are many reasons the 3 trustees had for this action and other recent actions. There may be reasons, I'm sorry. I would imagine there are many. Their failure to work on these issues with staff before bringing them on at meetings makes me think they have some other agenda other than how to make the best public school system for the students. I'm at a loss to see how the public accusations against staff and the superintendent are the best way to serve the children's interests, which is their role. If they had an agenda to cool down the district, in public view and replace it with some other personal vision, I would better understand their actions. If any or all of them had a better plan for educating the students of this district, it's their duty to share it and work with the educators and staff to implement it. Tearing down people and programs is always easier than implementing well thought out, vetted, and research-based decisions. I do agree that trustees have to be free to express their viewpoints, but this should always be done with respect. Part of this respect is letting staff know what your concerns are and giving them a heads up so that they can be prepared for any public hearing. This allows staff to have answers for the concerns and helps the public get a clear view, a clear picture of the state of issues. I'm asking the elected trustees to continue to ask questions and to express themselves, but do so within the bounds of accepted board behavior for the sake of the public school students, which should be their main agenda.
Thank you very much, Ms. Sullivan. Our next speaker, Swanee Edwards.
Good afternoon, board members. I moved here 26 years ago from Portland, Oregon. But when I moved here, one of the first things I tried to do was learn about my community, understand the issues. I'm from a political background, as some of you may know. I found Morgan Hill instantly the place that I wanted to spend the rest of my life, just by having lived here after a job for years. So I became invested in the community. Luckily, throughout that process, the man I married has shared his 3 children and 7 grandchildren with me as part of the family. After many years of seeing what I felt was substandard educational policies, a lot of strife, a lot of bad press, not being able to go forward within the school district here with several superintendents that I take care of personally, I was just so happy and relieved and positive when I met Mr. Antonio at an event My grandson, I'm proud to say, is an A+ for Cornell student at Colorado High School. This is his second year. He's a junior. He is going to go on to do great things. And we removed him from a private school in Ferndale to put him into the school district. So happy and grateful that he made that decision. I would like to extend my wishes to the board as well, that you would favorably of the contract. He's an important member of the community and he's definitely involved with my kids. He was at both award ceremonies when my son received his certificate, my grandson. And I feel it's really taken a huge weight off the community and have us moving in a positive direction. Thank you.
Leaders Edwards. And our last card is Ms. Claudia Russell.
Feels a little strange to be on this side. President and eventual esteemed members of the board and cabinet, I am proud to be here as your representative on Santa Clara County Board of Education. And in that position, I've had the pleasure and pride of hearing about the accomplishments of Morganville Unified. When you enter the Santa Clara County Office of Education, Morganville Unified is prominently named as recipient of an award for seal by literacy. Additionally, presenter Kathleen King, CEO of the Healthier Kids Foundation, cited our district as being on the cutting edge of partnerships that have resulted in making sure children of socioeconomic disadvantaged backgrounds have access to health insurance, dental screening, vision screenings. This is very important as you educate the whole child and family. Also, in a separate presentation by Dr. Angelina Ramsey, Sobrado High School was cited as spectacular in its partnership with the Equal Opportunity School and Santa Clara County Office of Education. This is a partnership that has resulted in providing access to AP courses to students that would never even consider participating and enlisting for those courses. These are important matters, and Morganville Unified has been consistently cited as being on the cutting edge. More recently, the California State Department of Education has awarded 4 of our schools with the California Gold Ribbon Awards. Project Cornerstone has also awarded our schools with the Caring Climate Awards. These are awards that set us apart from other districts in the most enviable way, and I am very proud of that. And I am bringing this up in the context of your evaluation of Superintendent Tondo, somebody that I wholeheartedly support. I wholeheartedly support his good judgment in creating the partnerships that have resulted in these accomplishments. Additionally, in having the fortitude to take personal and rabid hits for his principled stance when it comes to corporate charter organizations that seek to enter our district to profit from our school system. I'm citing an article from the Gilroy Dispatch, which cites grave concerns around navigators' finances, the lack of a voice for parents, lack of supplies, spending priorities that don't put kids first. These are all concerns that staff and our superintendent cited when we denied Navigator access to our school system. So in evaluating Superintendent Tondo, I urge you to consider his good judgment and all the accomplishments of a district that is, I think, moving in the right direction.
Thank you, Ms. Wilson. Having no other speaker cards at this point in time, the board will adjourn to closed session to discuss the 2 items on the agenda. There's no time limit. The first item, item B1, public employment / public employee performance evaluation. Earlier, Government Code 54957, title of superintendent. And item B.2, conference